Good evening and welcome to Lawyers on the Line. I'm Stephanie Balmer, an associate attorney at the Duluth law firm of Falsani, Balmer, Peterson, Quinn, and Beyer, and this evening's moderator. Tonight's topic is premises claims. People can suffer severe injury when on the property of others, whether in a hotel, restaurant, store, or apartment building. You need to know the rights and obligations of anyone involved in such an injury. Now I'm pleased to welcome tonight's panel, Jim Balmer, founding partner at Falsani, Balmer, Peterson, Quinn, and Beyer, Jim Peterson, a partner at Falsani, Balmer, Peterson, Quinn, and Beyer, and Steve Rialts of the Rialts Law Firm. Please call us with your premises claims questions at 218-788-2844. Or if that's long distance for you, you can call our toll-free line at 1-877-307-8762. Well, the first question we have tonight is a pretty basic one. We'll start with you. If I slip and fall at my own house, who can I sue?
Usually nobody. The idea, just because you get injured on property doesn't make it automatically somebody's fault. In order for you to have a claim worth pursuing, you have to be able to show that somebody was negligent in bringing about your injury. That is to say, you have to be able to show that they failed to do something they should have done to protect you and others from injury. Usually, if you fall on your own property, you're the person that should have taken the precautions to prevent injury, and you cannot sue yourself, so there's nobody you can sue.
We also have a call from Duluth. If I fall in the parking lot at a convenience store, can I sue the store? Jim Peterson, what do you think?
Well, again, if someone's negligent, sure. If they failed to remove the snow or ice within a reasonable period of time, that can be negligence. If they remove the snow or ice in a bad way and it's still icy, that could be negligence. Theoretically, maybe there's some outside contractor that should have made it safe and failed to do so. But again, just because it happens on the property doesn't make anyone liable.
Can I add to that?
You may.
Yeah. Steve and I had a case a few years back where somebody fell in a parking lot. And I represented the individual who was hurt. And in that case, it was not a convenience store. But in that particular case, I contended that Steve's client should have salted or sanded the parking area. And it was after one of these ice storms we had a few years back. And we wound up settling the case. But that's a situation where I could at least contend that something more should have been done than was done. And that's an example of it where you've got a commercial landowner like a parking lot of a shopping mall in that particular case.
If I can add to that, to what Jim was saying, in a case like that involving an ice storm or a snowstorm, the law is pretty clear that the property owner, whether it's a homeowner or a commercial property owner, has until the event is over, a reasonable time until the event is over, to clear the property. So if you have an ice storm, you don't necessarily have to be out there in the throes of this ice storm putting salt out. But a reasonable time after the storm is done, you need to remove the snow or spread the salt or do whatever you need to do to make the area safe.
Yeah.
We'd all have bursitis here at the end of this month if we were having to shovel in an ongoing fashion. So here's a question from Superior, Wisconsin. My son lives in a frat house. If he is beaten up at a party, who can he sue? Anyone.
Well, I'll take that one. It's often the fault of a landowner is might be predicated on some criminal act that's done at the landowner's premises, and there's a whole body of law about what criminal acts a landowner might be responsible for if the criminal act is done on their property. There was a recent case at the U of M, down University Avenue where there's Fraternity Row.
Frat Row.
Yeah, Frat Row. And there was a young fellow who was a member of the frat, or was invited to a frat party. I don't think he was an actual member of the fraternity. He was beaten up and it was a party where like there were 400 or 500 people invited. But the Minnesota Supreme Court ruled that that there was no duty of that frat house to him to prevent him from being beaten up in a circumstance where someone just got into a quick fight, where there wasn't advance notice, and he was beaten up. So it's kind of what Jim was saying about being reasonable. If a landowner has to do what's reasonably prudent in the circumstances, but you can't necessarily predict that someone is just going to get in a fight with someone and beat them up. So at least for that frat house case, the fraternity was not responsible.
The person who did the beating up would be liable. It's not only a criminal act, it's also a civil wrong, so that you could sue the person who did the assault, but it's not an insurable thing. So normally people who go around to frat parties and beat other people up don't have the kind of assets that you would want to.
So if you were to sue someone who did beat you up at a frat party, there wouldn't likely be any insurance coverage. You'd try to recoup their car or garnish their wages or something like that. Right.
It's kind of interesting, if I can interject, we had a very famous case in Duluth that involves that same kind of thing, and this had to do with the Congdon murders, and Velma Pietola, the night nurse who was murdered, while at the Congdon mansion, and of course everyone remembers the criminal cases that arose out of that, but there was a civil case that was tried here in Duluth, where the heirs of the nurse, Velma Pietola, sued the trustees of the Congdon estate and others, saying that they should have done something to have protected her from a criminal act, that is the break-in and the murder. And ultimately, the Minnesota Supreme Court said no, that there was no duty under those circumstances to protect her from the criminal act, the break-in.
The key is whether the people owning the premises should have realized there was this risk from some other person. Steve and I had a case where my client was assaulted in a tavern by one of the customers. My client was one customer, and there was another guy who attacked him. Well, actually, a couple of his friends attacked him and beat him up pretty severely, although he apparently enjoyed an excellent recovery as we look back on it. And but the point is that the issue in the trial between my client and Steve's client, and Steve represented the owners of the tavern. The issue in the case is whether the owners of the tavern ought to have foreseen the risk of harm to my client from the criminal acts of this other customer. And that was the problem in the fraternity house case. It was the problem in the Congdon murders that Steve was just telling us about. And if somebody makes an attack on my client that was completely unforeseeable, that nobody had reason to expect, then the owner of the property is not legally responsible. But if the guy that perpetrates the attack was a troublemaker, had been in trouble before on the premises, and generally was somebody that the landowner knew or ought to have known was dangerous, then the landowner might have responsibility.
If I can add to what Jim was saying about that case, I mean, and that was a perfect case for this issue, because the question is whether or not, in that case, the bar owner should have been on notice that this was a dangerous situation. And I think it was a tough decision for the jury, because there had been this little skirmish beforehand, and then a couple hours later there's this assault, and everything had been calmed down in the meantime, and Jim was arguing that the bar owner should have ejected or evicted or thrown out the person who was eventually the person who committed the assault, or if everything just was back to normal and seemed fine, and then the bar owner, they really had no duty to throw them out. It was a judgment call, and that's one of the problems with these things. If you're a bar owner, you're trying to decide, okay, was this little skirmish a big enough event that I need to kick someone out of my bar, or was it just a little argument that everything's over with and fine, and there isn't going to be anything more. So those are difficult decisions to make for bar owners, and apparently the jury in this case, which sided with Jim's client, felt that the bar owner should have done something more than the bar owner did.
We've got a question from Duluth. An owner of a rental property called in to ask whether posting a sign that says no trespassing provides him or her with an extra layer of protection. Jim Peterson?
This is a commercial establishment that just puts a no trespassing sign where? Inside the business?
Does that matter?
Well, it might if it doesn't mean anything. There is a different standard of care for people who are lawfully on the premises versus people who are trespassing. Okay, so that if someone gets hurt while really trespassing, then the landowner is not going to be liable unless the landowner has undertaken some sort of activity that created a hazard on the property. Okay, it's not just passive, I didn't shovel the sidewalk, sorry you fell. It's some sort of hazardous activity so that even a trespasser is protected by the law. But just putting a no trespassing sign, say, behind the bar probably isn't going to change the standard of liability.
We have another question. This is from Proctor. My sidewalk in front of my house pools. We called the city. They sent a guy out. He said it was fine. They're on the list for this year to maybe get it fixed. Water is continuing to pool. If this pooling water either causes an ice buildup or it becomes slippery in some other way and someone ends up getting injured, is the landowner liable?
Let me start and we'll go down the line
Sure.
here. I think if the landowner is aware of the potential hazard presented by the pooling water, the least they should be doing is warning potential users of the sidewalk that there's going to be an ice buildup on it in cold weather. Putting a sign out, a warning, icy sidewalk, I think prudence dictates that perhaps some sand or salt be put down on it in cold weather, in addition to putting a sign up. Just put out some sand when it falls below freezing or whatever. But the interesting part of this is that there's at least theoretically a potential claim against the city of Proctor for somebody who gets injured. If the city of Proctor is aware of the problem, has agreed to fix it, and then doesn't, I think that a creative lawyer could mold a theory of legal liability against the city of Proctor for that. And I'm sure that if somebody gets injured there and hires a lawyer, that lawyer is going to consider that possibility.
It's tougher to sue municipalities because for some of their decisions they make, they have immunity.
Right.
And so in the Jim scenario, if they have notice, then that makes it a little easier to get over that immunity hurdle.
What were you going to say?
There's another issue with a municipality or a city, and that is there's a statute that says that if a city owns a sidewalk that abuts private property, and I'm assuming this is the sidewalk that goes, along the street, not, the landowner's sidewalk, the city is not liable for the accumulation of snow or ice. Now, maybe you can get around that if there's some sort of a, negligent construction or failure to remediate, but I don't know if that's the case. There is also common law established by the courts that say that if you've got a freeze-thaw pattern and the ice that forms is smooth and doesn't have hillocks, furrows, and ridges, then the city's not liable. And the reason is because that's what courts decided about 110 years ago for some reasons. But
does that rule of law apply to the state of Minnesota, Jim?
I assume it does now.
Okay.
We'll change tacks a little bit. This is a question from Duluth. My dog has been chained up in my yard, but a neighborhood kid got bit. Why should my insurance company have to pay?
Who gets to go first?
You seem to want to.
Okay.
Go ahead.
Yeah. When I started, my first answer to your first question was that in order for a landowner to be held legally responsible, they have to have been negligent. And negligence is the failure to do something that you really should have done to prevent harm. That does not apply in the case of a dog bite. If a dog attacks somebody where that person may lawfully be at the time of the attack, then the owner of the dog is liable whether the dog owner was negligent or not. It's called the first bite statute. And what that means is this. We've all heard the phrase, every dog deserves one bite. What that means is that you're not liable as the owner of a dog until you know the dog is vicious. And you generally know a dog is vicious if the dog has attacked somebody. Then if it attacks a second person, well, then presumably you should have known better and have taken steps to protect people from your dog, whom you now know to be vicious. After the Second World War, I think it was, states began enacting first bite statutes, they're called, which are statutes that hold dog owners legally liable for the first bite, not just for the second bite and any subsequent bite. So yeah, if somebody comes on the property and the dog bites them, they're probably responsible. Now, if it's posted no trespassing, if the dog owner's put up fencing and done all that any reasonable person could do to prevent people from getting in near his dog, and somebody climbs onto the property and goes and irritates the dog and provokes it and all those kinds of things, maybe no liability. But generally speaking, if you own a dog and the dog bites somebody, you're probably going to have to report it to your insurer.
And it isn't just bites. You know, I've handled a lot of dog cases, and it can be an attack. You know, I mean, without a bite, it can be someone jumping, even a dog lunging at someone if there's no physical contact, and the person who's lunged at recoils and falls and injures himself. That's still covered under what we call the dog bite statute, but it's still part of that statute that Jim was referring to.
In Wisconsin, it's the same rule for the first bite, but if your dog bites somebody and then there's a second bite, you get double damages. Because of you already know your dog has a propensity to bite, and now you're doubly liable.
What about cats?
I think cats are still second bite, but I think there's a bill in the legislature to extend that statute to cats.
Okay.
My partner, Bob Folsani, handled a dangerous cat case years and years ago. I don't remember the outcome.
Oh.
I was a mediator on a cat case where there was a cat identification issue.
That wasn't my cat that attacked you?
Right, and so we had a kitty lineup, and then there was an identification of which cat it actually was. So.
Oh, we shouldn't laugh too hard. I mean, it was a case. All right.
Kitty lineup.
Kitty lineup, that was funny. Here's a question from Duluth. The mailman cuts through snowbanks instead of on the sidewalks. What if he slips and falls in my yard, but not on the sidewalk?
I had a case like that.
And?
I got a settlement for the letter carrier. I think the issue depends in that case on whether there's a well-worn path so that the landowner is on notice that the letter carrier is not using the sidewalk. Now, if the landowner has failed to keep the sidewalk clear, and that's why the letter carrier is avoiding the sidewalk, then I think the landowner may have a problem. But if the landowner's done all that any landowner could be reasonably expected to do to make the sidewalk safe for use by the letter carrier, and the letter carrier refuses to use the sidewalk, then I think it becomes the letter carrier's problem. Although the letter carrier would have a workers' comp claim against the Postal Service.
Mr. Peterson, you have anything to add there?
No.
Okay. Here's a question from Duluth. If someone goes off the road in an ice or snowstorm, they can't sue the state or city for not maintaining the roads. But if someone falls in an icy parking lot, they can sue the store owner. What is the difference? When do people just take responsibility for their actions?
I want that person on my jury.
Yeah, I bet you
On the
do.
defense side, but.
A whole jury full of them would be nice, huh?
Well, you know, if you're going to someone's home, or if you're going to a commercial enterprise, a convenience store, I mean, there's an expectation that people are going to care for that property, and it's a little different when you're talking about taking care of hundreds and hundreds of miles of roadway, like the state has to do. So, so I think that's the distinction there. but you know, not everyone's there isn't necessarily liability just because you slip and fall on someone's premises. As Jim and Jim were saying earlier, you know, you have to prove that there was some fault, and so you have to prove that that something should have been done to alleviate that problem. Another thing that that we like to use on the defense side is that a property owner isn't responsible for an open and obvious danger. So if there's snow sitting there and someone chooses to walk over the snow rather than going around it, and it's open and obvious to them, then the store owner isn't necessarily liable for that. Or if there's a hole, but the hole is open or it's been marked, and someone steps in the hole, but it's open and obvious, then the store owner isn't necessarily responsible for that either. And I think that's a good part of the law. It does force people to take responsibility for themselves.
One last point about that is this. The state has simply legislated itself some immunity for a lot of the things it does that would get a private business into trouble. In other words, the state has passed statutes that just say you can't hold the state legally responsible for these things, even though if the person who caused the harm was not the state, but instead was a private business would be liable under those circumstances. But the state has chosen to erect barriers to liability for it around itself, and a typical taxpayer thinks that's a great idea because they think it'll keep their taxes down because you're not paying all these claims. But then the typical businessman says, well, wait a minute, how come the state gets to get away with this stuff and I can't? And I can understand the frustration of the person that asked the question. But some of the reason that the state doesn't have to pay out on this stuff is because the state has insulated itself from liability. It's really not a question of personal responsibility.
Well, let me just say that as far as personal responsibility goes, we all have our own responsibility to not be negligent for ourselves, right? And so if someone is carelessly running across a slippery parking lot wearing ballet slippers and falls, then they are negligent as well, potentially, and then the law would require a comparison of the fault. So maybe the landowner is 60% at fault and the injured person is 40%, for example. So you certainly have responsibility to watch out for yourself also.
Before we leave the personal responsibility part of the slip and fall too, and you know, we talked about fault, but people should be aware that there is a type of insurance coverage that covers some medical expenses for slip and falls on homeowners' property or in commercial property. It's called med pay coverage, and it's often ignored or not known of by the owner, and sometimes it's there and available. So for instance, if Jim's a runner and if he's running from his place on Park Point by my place on Park Point and decides to run up my driveway to get a glass of water because he's parched and slips and falls, whether he's at fault or not, I have homeowners coverage that has $1,000 or $2,000, or sometimes the commercial properties have $5,000 of med pay coverage that would cover him for his medical expenses. Usually there's a time limit too, like a year after the incident. So there is some small amount of coverage that covers those medical expenses, and it's something you pay for with your premiums. It's a good benefit for the people who are on your premises, and sometimes it prevents people from suing you.
Yeah.
You know, if there's some money there to cover their medical expenses, then they don't feel they need to start a lawsuit, make a claim, make a liability claim.
Right.
Well, and that brings us to another question. A woman in Duluth wanted to know if someone gets hurt in someone else's home, does the homeowner's insurance pay or that person's health insurance if they've got it? Why make a claim?
Well, if most of the people that come to our law firm come there because they're worried about how to pay for their medical expense. If you have your own medical insurance coverage, these days, frequently, it's not very good coverage. You have a high deductible, sometimes several $1,000s, and so in order to get your bills paid, you might have to shell out $4,000 or $5,000 of your own money, and a lot of people can't afford that. If you make the claim against the homeowner's insurer for the people who own the premises where you were hurt, then not only will you get your own money back if you prevail, but in addition to that, your own health insurer gets reimbursed by the homeowner's insurance company for the money it paid you. You don't get to keep the money from both companies. The amount of your recovery is typically reduced by the amount of fault that a jury decides you have. Jim was talking about somebody being 40% at fault when they slip and fall in an icy parking lot. In a situation like that, you would only recover 60% of your damages because the amount of your recovery is reduced by your proportion of fault for your own harm.
We have time for probably one last question, and I like this one as the child of a personal injury lawyer.
You're also a personal injury lawyer.
That's true,
yeah.
But a caller wanted to know, we can't have a trampoline in the yard according to my wife. My kids are safe. What's the problem? You wouldn't let me go on trampolines, go water skiing, wakeboarding, none of that. What's the problem? What's the big deal? Mr. Peterson, I already know how he feels.
Trampolines are unsafe, and they are going to attract neighborhood kids. And I know people who think that if you put a trampoline in your yard, you're not even insurable because they're dangerous. They can be dangerous in ways you can't anticipate. You can't always be there to ensure safety. And even if you are, two kids might be jumping and one comes down at the wrong time and the thing is off balance. And I personally think they're very dangerous.
What if you put those the gates around them? You know, they have those nets and the bars where. Yeah.
Yeah, I agree with Jim and Jim. I mean, they're dangerous. I mean, you can get insurance coverage for anything. It's probably something you have to disclose. We need an insurance agent here to answer that question. If you've got a trampoline, just like if you've got a dock or if you've got a swimming pool. I mean, there are a lot of things in life that create risk, and you just got to decide if you want to bear that risk or not. And you can probably get an endorsement to cover trampoline injuries, but I think they're pretty dangerous.
Do you have to report every injury? Oh, that's all the time we have tonight. But we wanted to let you know that you can have your questions on tonight's topic or any legal topic answered every Wednesday at noon at the St. Louis County Courthouse through the Volunteer Attorney Program's Ask an Attorney service. Call 723-4005 to make an appointment. You will get 10 to 20 minutes one-on-one with a local volunteer lawyer who will be able to answer questions and lead you on the right path to find the additional legal help you may need. This program is free and available to the public regardless of need. Remember, you can watch tonight's program again online at wdse.org or on the Falsani, Balmer, Peterson, Quinn, and Byer website. Please join us again next week when we answer your questions about other legal issues. I'd like to thank our panelists for their expertise this evening and thank you for watching. I'm Stephanie Balmer. Good night.